This issue of Kano State is worrisome because of the angle of the judiciary in it. I am not from Kano State, and I'm happy that the two emirs that are in question are all from the same descendant. They share the same father. So it's not an issue of siding anybody because I'm not from Kano State. They are from the same family. It's quite unfortunate that they are allowing politics to come in to divide them. What is happening in Kano State as it concerns the Emirate of Kano and the stool of the Emir is political. And politics has no business with the traditional institution. It's supposed to be a sacred institution that is upholding the culture of the people. Now, I'm delving into it purely to bring out the legal implications of what has happened so far. I am aware that some time ago that Emir Sanusi was chosen when it was the regime of Kwakwanso to be the Emir of Kano. I am aware that Ganduje came in, and Ganduje alleged that Emir Sanusi misconducted himself, queried him, and believed that he found him wanting, and then deposed him, and then banished him. I am aware that in the ancient days, whenever any emir is banished, or whenever any emir is dethroned, he is banished. Sanusi's own grandfather, or Diaraba, that was an emir, he was dethroned and was banished. I'm also aware that when the Sultan of Sokoto, Dasuki, was dethroned, he was banished. And I'm aware that when Sanusi was banished, he went to court. And the court he went to was Federal High Court. He was banished based on the chieftaincy law and then the convention, because that has been the convention. And the Federal High Court assumed jurisdiction and rightly, in my own view, held that his fundamental rights were impinged on. And since the fundamental human right is a constitutional provision, it towers above the ordinary laws of the land. So it takes preeminence before the chieftaincy laws. But the point here I want to make is that what it meant was the Federal High Court had jurisdiction, even though the banishment stemmed from chieftaincy law. But because the substance of the issue was fundamental human right, the Federal High Court assumed jurisdiction, determined the case, and gave judgment in favor of Emir Sanusi as to his fundamental human right that he's not supposed to be banished. So it was the Emir that asked that he doesn't mind staying away from Kano, but his freedom of movement should not be restricted. And I use the word rightly because the Supreme Court has held that the Federal High Court and the State High Court have concurrent jurisdiction on the issue of fundamental human rights. Having said that, I am aware that when this present governor came in, he seemed to be pro-Sanusi, being a protege of Kwakwanso. So, during Ganduje's time, the law, Kano State Emirate law, or thereabout, was amended, and they created more Emirates from Kano. And when they created those Emirates, I'm aware that Emir Sanusi still retained his position. So it was not the amendment of the law that removed Emir Sanusi. What that means is that you are expanding an emirate or you are shrinking it has nothing to do with the stool of the emir, because the stool of the emir was existing before even we had our independence. So shrinking the size of it by law or expanding it has nothing to do with the stool of the emir. That was why when Ganduje amended the law to create more emirates, Emir Sanusi still remained the emir of Kano. It was when Ganduje alleged that he misconducted himself and queried him that Ganduje now deposed him. Now, Ado Bayero was installed to become the emir of Kano. So when Governor Yusuf came, so I'm at a loss. Why that you amended the law to say the Emirates that were created are no longer there, but the Emirate of Kano is still there. So I'm at a loss why you should now go further to say that the stool of the Emir of Kano is now affected by law, and then Ado Bayero should leave his seat. And you have not alleged any misconduct, and you have not queried him. Then you even ordered his arrest at a certain point. And Ado Bayero went to court first on fundamental issues, which he went to Federal High Court. And in my own opinion, as a lawyer, the Federal High Court has jurisdiction to entertain the matter. And they gave him judgment. You can't arrest him. You can't, you must guarantee him his freedom of movement. These were almost exactly the same cases that Sanusi took to court. His freedom of movement, liberty, and the court granted it to him in Federal High Court, Abuja. So Ado Bayero himself went to Federal High Court, and the Federal High Court also granted him reliefs. And in my own case, he was not even granted a fair hearing because nobody accused him of any misconduct. Now, there was another case brought by one Alhaji, is it Aminu, is it Ngodi or something? But is a Sakin Dawa Baba or something like that. He brought the case. He took it to the Federal High Court. Now, listen to that case. The judge granted an interim order saying every party should maintain status quo. An ex parte order pending the hearing of the motion on notice. Get the point now. During the pendency of the interim order, the governor of Kano State went ahead and installed the emir, as in Emir Sanusi, as the emir of Kano. Now, the judge now came back and said, because this order was subsisting when you installed the emir, you have breached the order of this court, which is against the law. Because the law is that any order or judgment of a court must be respected, no matter how perverse, except it is set aside on appeal or vacated by the court that gave the order. So the judge was simply saying that since you did not obey this order, all your actions are a nullity. They are not valid because they are against a subsisting order. The substance of the matter has not been tried. So I was thinking the governor ought to take a cue, obey the order, go back and say, okay, we acted in error. And then go back to the court, file a counter affidavit, and then see whether the court will vacate the order or go on appeal, knowing that all the things he has done about the Emir Sanusi is now a nullity, since it was done against a subsisting interim order. Hear the point now. I'm not talking about the substance or the substantive matter. A court has jurisdiction to determine whether it has jurisdiction. So when a court is in the process of determining whether it has jurisdiction, and you go ahead to tamper with the rest, which the court has already by order restricted everybody, every action that you undertake during the subsistence, during the subsisting order, is a nullity. So, meaning, strictly speaking, by law, that every action that brought Emir Sanusi was a nullity since it was done against a subsisting order of court. Now, I'm at a loss how the Court of Appeal will now say they are quashing the judgments of the Federal High Court because the Federal High Court does not have jurisdiction. I believe, as a lawyer, that the Federal High Court does not have jurisdiction in the substance of the chieftaincy because it is a local issue. But the Federal High Court has jurisdiction to give an interim order, even if it has not talked about the substance. If I remember very well, the Federal High Court refused the plaintiff's plea to declare that law illegal. So the Federal High Court did not declare that law illegal. The Federal High Court simply said that every act done when this order was in place, and I'm not talking about whether the order is right or wrong. No. I'm saying there is an order of court which the law says you must obey until either overruled by an appellate court or vacated by the court itself. So I think the Court of Appeal erred in law by saying the Federal High Court does not have jurisdiction, because I know that the Federal High Court has jurisdiction on fundamental matters, and I know that pending the decision by the Federal High Court whether it has jurisdiction, the Federal High Court has jurisdiction to give any order which restricts the parties to maintain status quo, pending for it to determine whether it has jurisdiction. And I know as a lawyer that any action that you carry out when there is a subsisting order of the court is void and a nullity. Here is the catch. I am not saying that the Federal High Court has jurisdiction to try matters under the state chieftaincy law. No. I am saying that if there is an order of a Federal High Court for parties to maintain status quo, pending whether the Federal High Court, pending when it determines whether it has jurisdiction, any act done within that time is void. Not because it did not, or whether it conforms with the state law or not, but because there is an existing order of court that was flouted. If you do not protect orders of court, the next thing is anarchy. So I think that's why I use the word political. So respectfully, I think in the eyes of the law, Emir Ado Bayero is still legitimately, or should be, in my own opinion, still be the Emir of Kano, pending the determination of the Supreme Court. I know that there's also a state judgment, a judgment from the state court, so which are contradictory. So the Supreme Court should take up this matter and realize the implication that if you now say that when you remove a community from the kingdom of a traditional ruler, that the traditional ruler has now lost his seat, then that what it means is that I can go to Onitsha and remove one little village from the Obi of Onitsha's kingdom and say that the law has nullified the seat of the Obi, or go to Ife and remove one kingdom, say I'm doing an amendment that this little village is no longer part of this Ife. Like when they divided states. When they divided states, the governors then did not lose their seat because they divided states. You appoint a new governor to the new state. So it's dangerous for you to say that you amended a law and then you removed some Emirates from an existing kingdom, and you say for that reason that the emir has lost his seat, it is not tenable. So morally, legally, until Ado Bayero is alleged to have committed an offense or a crime against the traditional institution and tried and given fair hearing, for me, it will be an injustice and a bad precedent to remove an emir, to remove an oba, to remove an obi on the pretext that you amended the law and the kingdom was either enlarged or reduced. And then on that reason, a traditional ruler will lose his seat. It's a dangerous precedent. So for me, if Governor Yusuf has anything against Ado Bayero, he should bring it out openly, give him fair hearing. If he is found wanting, then you depose him in accordance with the law, then install a new emir. Anything short of that is an injustice and a dangerous precedent to the traditional institution. It could be an Oba tomorrow. It could be an Obi tomorrow. It could be an emir tomorrow. Whoever has not offended the law must not be punished by political consideration. You know, one of the things about rule of law is that you can punish somebody within the law, but you cannot punish somebody outside the law. So Adebayor, in my own opinion, has not offended any law. At least none has been told the world, and should be allowed to remain the emir of Kano.